Good morning, class. I'll start with my next lecture in business communication today. Our chapter is negotiations and legal aspects. Okay, it is essential to understand that negotiation in business is required. If you want to trade and do business, you have to negotiate. It is a method by which people and businesses settle differences. It is also a process by which compromise or agreement is reached while avoiding argument and dispute. However, many business deals go awry as they are not aware of the power of negotiation. The objective here is to understand negotiation and legal aspects. So, we all do negotiate in our daily lives. We know what negotiation is: bargaining for something. We as humans know the power of negotiation, the power of bargaining. This is how the businesses also have to negotiate. They have to bargain. If you are preparing for a business deal with another business, you should know how to bargain because they would want the best for their organization. For example, you're going into a joint venture with a company, and this joint venture, certainly it comes with certain agreements. So what is best for your company, you have to decide it. The other company would decide their best interests before getting into an agreement with you. So this is where the negotiation comes into process. Let's see how it works. What are the phases of negotiation? It has 4 phases. Preparation, opening, bargaining, closing. So preparation is what? You have to know what your best interests are. You just cannot go on the negotiation table, sit without any preparation and just sign the agreement. You have to be prepared. You should know the market trend. You should know what supply, what demand is of that particular product, anything that you are getting into a business deal with. Opening. While making the opening, or rather while opening the deal, you should give the best shot. Present your best side, because that is when the other side would be very much interested in listening to you. Opening of anything, of your kind of a report, anything that you do, the other side, when you introduce, that is the most important part. So businesses also need to know that the opening should be the best. Bargaining, you have to bargain. Bargaining, what bargaining means? Persuading the other side. We do bargaining every day while going to a shop, while going to purchase anything. We do price. So we all know. Closing. How you close the deal. Is it something you have got which is good for your company, which is needed? Really, that's something that you needed. Have you got that? You also need preparedness for this, because if you are not prepared, you'll not get the best of deals and it may be a loss for you. These are the approaches: integrative or win-win approach, distributive or win-lose approach. So integrative means both parties, the business parties where you are doing negotiations, both parties get something that is a win-win situation for them. They both integrate, they both cooperate together and then get into an agreement, seeing the best of the interest for both the parties. The other is win-lose situation, wherein one party wins, the other party loses. This is not a very good situation because ultimately the party which is losing would understand and the deal may go berserk, or even after getting into an agreement, even after starting business together, they may part their ways ultimately. Opening negotiations. Opening negotiations is a crucial step that sets the tone for the rest of the bargaining process. Certainly, The purpose of the opening is to create the proper setting for the upcoming negotiation. Yes, it does. The following guidelines helps in negotiations. As I said earlier, the opening of a negotiation is very important because this is when you tell the best of your company, best of your organization to the other side. Listen, anticipate, and compromise. Listen very carefully to the other side. Anticipate. Guess what they are coming up with next. You have to, by seeing their opening, or by knowing their opening, you should anticipate what is coming up next and compromise accordingly. Avoid confrontation. It's very important to avoid confrontation. Once you get into an argument or confrontation, the deal is not going to happen. That is for sure. Even if it happens, as I said, it may ultimately go berserk and they would part their ways. Use of concessions. Certainly, you would want the best for your company, for your organization as managers. When you are negotiating a deal, an agreement with another company, you would want the best for your company, which certainly may not be very good for the other party. So, what is concessions for? Something that you can jointly agree on and something that you are ready to compromise. Concession trading, how you trade your concessions. Something you give, something the other party gives. Recognizing a losing trend, taking a break, moving the focus, trading a concession. Once you are on the negotiation table, you can easily recognize if the negotiation, if the deal is going in the right way or not. You should know that if it is going towards a losing trend, if you are going to lose this opportunity, lose this deal, you should recognize it, and after recognizing, you should take a break for some time from the discussions. Move the focus. You can move the focus to something else which is good for both the companies, and then try to get concessions, try to give concessions. However, while giving and taking concessions, you should anticipate the questions. You should not give, as I said, be ready for concessions, but you should not be ready to give so many concessions that the other party thinks that, okay, this is something not dodgy, this is something not very good. So that is the reason you are giving so many concessions to them. You have to understand everything should be, in fact, everything should be in a proper way. Don't give too many concessions, don't take too many concessions, because if they are giving just so many concessions, they are just giving it to get the deal, get the agreement done. Something might be dodgy there. So you have to see what is the best interest. Removing deadlock. Okay, so this is about salary negotiations. When you go for an interview, you once you clear the interview, how you negotiate your salary. Salary negotiations in an interview can also be considered as a sales meeting. Thus, communicating effectively and negotiating salary is one of its aspects. Stress the positive. Tell them your positive points. Don't really show them your negative points, because they don't want to see your negatives as of now. They know every person has negatives, but they don't want to see it as of now in the interview. Sell your sizzle. Whatever is written in your CV, the interviewer knows that. They would ask you questions based on that. Tell them something that they don't know about you. Tell them something, or any incidences that have happened in your previous office, or something of that kind that stresses the positive, that sells you. in a positive way so that the company may buy you. You are in fact you are selling yourself. So tell them something that they should be able to buy you. Asking the right questions, be positive, don't ask negative questions. Something which you should not ask in interview is, when can I grow? When can I grow with the company? When do you give as in promotions? This is not something to ask when you're giving an interview. Once you're done with the interview, probably then after that, once you have the offer letter and the interviewer asks you for any questions that you might have, then you can probably ask them some, just out of curiosity's sake. Negotiating the right package, definitely you have to do that to get a proper salary. Know your market value. You should know your market value. What is your qualification? What is your experience? And with this qualification and experience, how much a person is getting, or how much a person can get as salary. So you should know what actually your market value is. Challenging a poor offer. If an offer by a company doesn't suit you, so how to challenge it, you should know, but that should be in a proper way. You should not say something which is negative. You should say kind of, is this the best you can offer? All right, so I'll have to think over it. I'll think and let you know. These are some phrases that you should speak. You should not say, okay, no, it doesn't suit me, I'm sorry, I'll not accept it. No, any kind of negotiations, when you are in any negotiations, be tactful. You have to be tactful. You cannot simply say, no, I cannot do this, I will not do this. You may say, I may not be able, it may not be possible. These are the words that would really impact on the other person. What happens next? Once you're done with the interview, you may ask, if you selected, you may ask, so what happens now? When do I join? Or the interviewer would give you details, but if there's something you want to know, you can ask them. Review your experience. You should always, when you go for an interview, when you're done with an interview, you should always review it, because that helps you in understanding where you might have given a good answer, where you need more practice, because even going for an interview needs practice. So you should know where you could have done better, where a better answer was needed. Write a simple thank you letter. It really isn't I would say it really isn't done in India. Normally employees do not write letters, but if you want to write, you can write it, and you really may not receive an answer from the manager, from the company, but they would certainly appreciate this, even if they do not answer you. Legal aspects of communication. Communication in writing form can be used legally. And if a manager is writing, sending an email, sending a letter on the letterhead of business, it can be used as a legal document. So in all of business communication, every possible care should be taken. Even a single carelessly chosen word may lead to a lawsuit. Many a times managers have to write letters and reports that require them to be aware of the legal aspects. They should also be aware of changing laws from time to time, which are warranted by changing social and business conditions. They should know what is actually legally, rather which is legally okay to be sent and which is not. The manager should have a clear objective legally of what they write. Yes, nothing illegal should be said. They should avoid any personal biases and opinions while writing and drawing conclusions. So no personal biases if you are writing legally. Some factors or strategies to be followed while you are writing a letter or a report that can be used as a legal document. Choose the appropriate legal environment. You just cannot write it anywhere. You should have a proper environment, proper place where you can write such letters or reports, because any every word written on it can be used legally. Schedule a reasonable block of time. Whenever you're writing a report, even a simple report, you need to pay attention to it. Choose some time, give yourself some time, block some time for it, and then write. State your purpose in legal writing. Engage in free writing. You can write, if you're preparing a draft report, you can write as much as you want and then review it, how it may suit you, how it looks to you. Avoid a perfectionism legal syndrome. While writing a draft, while writing an outline, you don't have to be legally perfection. You don't have to be legally perfect. Avoid it as of now. Review it after you've reviewed, then you can probably go making the final report. Think aloud with legal aptitude. What people when write and when think and when they say is very different when they write, when they think, when they say. So think aloud. Anything that you think is okay, you can say it, and when you say, see if it is correct. Parts first. You can write the body first, then you can, based on it, then you can write the introduction, based on it, then you can write the conclusion. Normally the body is written first. Whenever I have written reports, I write the body first, and then along seeing the body, I can make the introduction. So this is how it works. So we have the case study here, people. An effective example of good negotiation is of United Postal Service. Exchange, it seems it's parcel service, and UPS union members. UPS is a postal service in the USA. What happened with them, it was their business strategy to hire mostly part-time workers. In the US and in the UK, there normally the companies, the warehouses, these services, Royal Mail, these hire part-time workers. They don't have many full-time workers. So what hiring a part-time worker does, they are not really responsible for these workers. They come, they are paid, sometimes they are paid less than what a full-time employee is being paid per hour. So it was quite attractive among young workers, as they could earn the same price which was negotiated by unions. But yes, as it says, they could earn the same price. Sometimes unions are strong and they argue for the same price, but mostly it is somewhat lower than what a full-time worker gets. However, working part-time meant little chances of job advancement, as they were not full-time workers. They could not get promotions. They could not get what happens when you're working part-time. Whenever you are needed, they call you. This happened with me when I was working as a part-time worker while I was doing my studies, while I was doing my masters. Whenever the company needed me, the agency would call me and I would go to work, and based on that they would give me money. Thus the Teamster Union, this was the union of UPS, after carefully working on its strategy, brought UPS to the negotiation table demanding rights for part-time workers. They presented the disparity by UPS amongst the full and part-time workers, such as salary, retirement fund benefits, etc. Part-time workers are just going there, working, getting their wages. That's it. They do not get any benefits from the employer. This was done by UPS to cut cost of maintaining a full-time worker. You don't have to give them retirement funds. You don't have any PF. They have retirement funds, we have PF. So any part-time worker, even in India, wouldn't have PF facility by the employer. Thus the union was able to call a strike, which had the support of the workers. Union prepared themselves and they called a strike. The workers union was able to get the best deal from the UPS for the workers. This included 10,000 part-time jobs were converted into full-time. 10,000. This means a lot. There were around 182,000 part-time workers. They got, at that time after the strike, they got 10,000 workers into a full-time job, and now after some time most part-time workers were given full-time jobs. So from 182,000, only 40,000 were then part-time workers. Almost all of them had been given job employment, or rather full-time work. Jobs that were made available to non-union members and contractors were made available to union members. So contractors, as in the agency, what companies do, they get into a contract with an agency and they get workers through an agency. So they stopped that. Salary gap between the workers types was brought down. Older car fleets were replaced because it is a postal company. They had trucks, and those fleets were replaced with new fleets. Maternity and paternity leaves were expanded. No actions against employees involved in on-the-job accidents and injuries. Probably they had they had a rule wherein they took action against employees if they indulged in an on-the-job accident. So this was completely shut off after the negotiations with the union member. Anybody can have an accident. If it's an on-job accident, so what? You cannot take action against them. So this was shut off. Thus the union was able to create a win-lose situation where UPS lost $1 million due to the strike that lasted for 2 weeks, and the union won. This was actually a case of win-lose situation. UPS had to give full-time jobs. UPS had to agree to all those things that the union wanted. UPS had to give full-time jobs. Many things were done. So this is a win-lose situation, and the union won. Why? Because they were prepared. They came to the negotiation table fully prepared. Alright, so that's about it, people. I hope this is clear to you. Do work on the questions that are given. Even in your book there are questions. Please do work on it. That's it from me today. Thank you for listening. Bye.